Hello everyone. Today we'll gain some basic knowledge about the Constitution of India through some multiple choice questions. So without wasting any time, let's get started with the questions. The first question is, in how many states the government headed by the Morarji Desai imposed presidential rule in 1977? The options are A 6, B 7 states, C 8 states, or D 9 states. The correct answer to this question is option D, that is, in 9 states, president rule was imposed in 1977. So let's gain information what happened in 1977. During 1997, after the internal emergency, the ruling Congress party lost and the Janata Party came to the power. The then Prime Minister Morarji Desai imposed president rule in 9 states, especially where the Congress party was in power, on the ground that the assemblies in those states no longer are represented the wish of the electorate. The next question is, which of the following are proper grounds for imposition of precedent rule in a state? Options are where there is a hung assembly, B, when a majority party declines to form a ministry and a governor cannot find a coalition minister, C, internal subversion, or D, all of the above. The correct answer to this question is option D, that is, all the above reasons are valid for the imposition of precedent rule in any state. This means to say that when there is a hung assembly or a majority party declines to form a ministry, if there is an internal subversion, or when the constitutional direction of the state government is disregarded by the state government, the precedent rule can be imposed in that state. The next question is, who can extend the term of the state legislative assembly during emergency? Options are the state legislature, B, the governor of the state, C, the parliament, or D, the president. The correct answer to this question is option C, that the parliament can extend the term of the state legislative assembly during emergency. Basically, according to the provisions of Article 172, Clause 1 of the Constitution of India, while a proclamation of emergency is in operation, the duration of the state legislative assembly may be extended by the parliament for a period not extending to 1 year at a time. So now let's understand what is Article 172 is. Article 172 deals with the duration of state legislatures. Clause 1 of Article 172 states that every legislative assembly of state, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer, and the expiration of the said period of 5 years shall operate as a dissolution of the assembly, provided that the said period may, while proclamation of emergency is in operation, be extended by Parliament for a period not exceeding 1 year at a time, not exceeding in any case beyond the period of 6 months after the proclamation has ceased to operate. So now let's move on to the next question. Which of the following statements are true about judicial activism? The options are A. It is a process of lawmaking by judges. B. It is a practice in the judiciary for protecting individual rights. C. Judges depart from strict adherence to judicial proceedings. Or D. All of the above. The correct answer to this question is option D. That is, all the above statements are correct regarding judicial activism. What is judicial activism? Basically, judicial activism is exercised by judges in favor of the progressive social policies, which are called for social engineering, by departing from the principle of strict adherence to a judicial precedent. It is also means to protect or expand the individual rights and therefore also referred as a process of lawmaking by the judges. Moving on to the next question. Who all are a part of state executive? Options are A. Governor, B. Chief Minister, C. Advocate General, or D. All of the above. The correct answer to this question is D. All of the above are the part of state executive. The next question is, what are the reasons for the system of appointment of governor by the president? The options are A. Direct election of the governor is incompatible with parliamentary system. B. It is better to have elaborate arrangements for the election of the governor. C. It is in the national interest to have large voters for the election of the governor. Or D. Direct election is less likely to create conflicts between governor and the chief minister. The correct answer to this question is option A, that is, direct election of the governor is incompatible with the parliamentary system. There are some reasons for the system of appointment of the governor by the president. These are as follows. First, the direct election of the governor is incompatible with the parliamentary system in the states. Second, direct election is more likely to create conflict between the governor and the chief minister. Third, there is no need to make elaborate arrangements for this election as he/she is just a nominal head. Fourth, since the election of a governor is on a personal issue, it is not in the national interest to involve large number of voters in such an election. Fifth, an elected governor would not be a neutral person as he should naturally belong to a party. Sixth, the election of the governor would create separatist tendencies. Seventh, the system of presidential nomination enables the center to maintain its control over the states. Eighth, direct election of a governor creates a problem of leadership at the time of general election in the state. And last, the chief minister would like his nominee to contest for the governorship, which is not desirable. So let's move on to the next question. In what situation the governor is supposed to reserve a bill for consideration of the president? Options are A. If it is against the provisions of the constitution. B. If it endangers the position of the state high court. C. If it deals with compulsory acquisition of property under Article 31A. And D. All of the above. The correct answer is option D, that is all of the above. Let's understand it in a better way. The governor reserved the bill for the consideration of the president in the following circumstances. First, if it is ultra vires, which means it is against the provisions of the constitution. Second, if it is opposed to the DPSP. Third, if it is against the larger interest of the country. Fourth, if it is of a grave national importance. Fifth, if it deals with the compulsory acquisition of property under Article 31A of the Constitution. And sixth, it is obligatory to reserve a bill if it endangers the position of the State High Court. So, let's move on to the next question. Which of the following are compulsory provisions of the 73rd Constitutional Amendment Act of 1992? First statement, organization of Gram Sabha in a village or a group of villages. Second statement, direct elections to all seats in panchayats at a village, intermediate, and district levels. Third, endowing the Gram Sabha with powers and functions at a village level. The options to the above statements are A. Only first statement, B. Only first and second statements, C. Only first and third statements, or D. First, second, and third statements. The correct answer to this question is option B, that is, only first and second statements make the compulsory provisions of the 73rd Constitutional Amendment Act 1992. The organization of Gram Sabha in a village or a group of villages and direct elections to all seat and panchayats at the village, intermediate, and district levels are compulsory provision, whereas endowing the Gram Sabha with provisions on the function at the village level is a voluntary provision. Now, the next question is who has the power to enforce prohibition or to regulate or to restrict the sale and the consumption of any intoxicant in tribal areas? Options are A. Gram Sabha, B. State Legislature, C. National Commission for Scheduled Tribes, or D. None of the above. The correct answer to this question is option A, that is, Gram Sabha has a power to enforce prohibition or restrict the sale and consumption of any intoxicant in tribal areas. Basically, according to PESA Act of 1996, the Gram Sabha is empowered with powers, especially with the power to enforce the prohibition and restriction of sale and consumption of intoxicant in their areas. The next question is on what criteria urban bodies like special purpose agency are set up? Options are A. Area, B. Function, C. Both of them, or D. None of them. The correct answer to this question is option B, that is, on the basis of function, urban bodies are set up. The special purpose agency are set up to perform a particular functions and therefore are not area based. That is why these are also known as single purpose, unipurpose, or functional local bodies. The next question is who administers the union territory? A. Prime Minister, B. President, C. Governor, or D. None of the above. The correct answer to this question is option B, that is, the President administers the regulation and the working of the Union Territory. It is done by an administrator appointed by the President. The administrator of the Union Territory is an agent of the President and not the head of the state. The next question is which of the following UTs or Union Territory come under the Bombay High Court? Options are A. Andaman and Nicobar Islands, B. Lakshadweep, C. Both of them, D. None of them. The correct answer to this question is D. None of them, that is, neither Andaman Nicobar Island nor Lakshadweep, comes under the Bombay High Court. The Andaman and Nicobar Island comes under the Calcutta High Court, whereas Lakshadweep comes under the Kerala High Court. The UT that comes under the Bombay High Court is Dadar and Nagar Haveli and Daman and Diu. The next question is who can appoint a commission to report on the administration of scheduled areas and the welfare of the scheduled tribes in the states? Options are A. Supreme Court, B. President, C. Governor, or D. Parliament. The correct answer to this question is B. President. The next question is which of the following is associated with the development of the urban local bodies in India? Options are A. The Government of India Act 1919, B. The Government of India Act 1935, C. Both of them, or D. None of them. The correct answer to this question is option C, that is both acts. The Government of India Act 1919 and the Government of India Act 1935 is associated and is concerned with the development of the urban local bodies in India. The Government of India Act 1919 was introduced by Darky in provinces, made local self-government a transferred subject to be handled by a reasonable Indian minister. Later, the Government of India Act 1935 came and stated the local self-government was declared a provincial subject. The next question is, who is the chief executive authority of the municipal corporation? Options are A. Mayor, B. Municipal commissioner, C. IAS officer, or D. None of the above. The correct answer to this question is option B, that is municipal commissioner. The next question is, which of the following are the sources of income for the urban local bodies? Options are A. Tax revenue, B. Grants, C. Loans, or D. All of them. The correct answer to this question is option D, that is all of them are the basic source of income for the urban local bodies. So let's understand about the sources of income of these local bodies. The urban local bodies have six sources of income. These are tax revenues, non-tax revenue, grants, devolution, and loans. The next question is, which of the following union territory have been created for the cultural distinctiveness? Options are A. Puducherry, B. Daman and Diu, C. Dadar and Nagar Haveli, or D. All of them. The correct answer to this question is option D. That is, all of them have been declared union territory on the basis of their cultural distinctiveness. The next question is, which of the following UTs have a lieutenant government? Options are Puducherry, B. Chandigarh, C. Dadar and Nagar Haveli, or D. Daman and Diu. The correct answer to this question is option A, that is Puducherry. The last question is, who is empowered to declare an area to be a scheduled area? Options are A. President, B. Parliament, C. Governor, or D. State Legislature. The correct answer to this question is option A, that is the President is empowered to declare an area to be a scheduled area. The President can also increase or decrease its area and alter the boundary, revoke such declaration, and fresh order for such redesignation of an area in consultation with the governor of the state concerned. The next question is, which of the following are the tribal areas located in Mizoram? Options are say first Chakma district, second Mara district, third the Lai district, fourth Jaintai Hills district. The options are only 1 and 2 districts, B only first and third district, C only first, second and third district, or D first, second, third and fourth district. The correct answer to this question is option C, that is first, second and third district are located in Mizoram. These three districts are Chakma district, Mara district and the Lai districts.